they're not developing. And like I said, I treat every client that I have that's a child like there's a whole story that
I have a duty to apply it in that way. And that's the most heart-wrenching decision that I make on a regular basis. Second one is whether to commit a kid to the state or not.
But unfortunately, we know that it's not a perfect world. So there are plenty of kids that have these issues that aren't going to be addressed in the adult system being sent to the adult system anyway.
Not true. And those that's one of the great things about the show, I think, is we can hopefully dispel for maybe a limited group of attorneys that watch it, that myth that you're under 18, you won't be doing any time isn't really the case. Hello, everybody. Welcome to Our Nevada Judges. I am your host, Scott Coffey, and today we're going to be talking about the kids, or more specifically, kids that have gotten in trouble, delinquency, how it works in the court system, and that sort of thing. For those that don't know me, I am the chief of the homicide team for the Clark County Public Defender's Office. I've defended those sorts of cases for the past 25 years or so. And while I have had some people that were charged as juveniles, I am not near as familiar with the delinquency process as our honored guest today. So without further ado, I'm going to introduce the people that we have with us. We have Amy.
I'm Amy Honodel. I am with Legal Aid Center of Southern Nevada and the Children's Attorneys Project, and I represent youth in foster care and dependency cases from 0 to 20 and 11 months. And in that capacity, I represent youth who also have delinquency cases. So I'm on both sides of the juvenile system representing youth.
Okay. And we've got
Baylie Hellman. I am a partner for the law firm Nevada Defense Group, where I am in charge of the criminal division, which handles both adult criminal actions and several different juvenile levels of criminal cases.
Very good. And last and certainly not least, joining us via Zoom is Judge Dave Gibson.
I'm Judge David Gibson, Jr., currently the presiding judge of the Family Division of the 8th Judicial District. Recently was the one of two judges hearing juvenile delinquency. I'm currently hearing dependency. Also have held a domestic calendar for some time. So presided in all aspects of our family court at this point, and might have a little knowledge to share today.
Very good. And I'm already intrigued and have a question for you before we even jump off. One of two judges hearing delinquency, you had to have a calendar that was about that tall, I would imagine?
It was a big calendar. We have 4 judicial officers currently covering juvenile delinquency, 2 district court judges. They will typically hear all of the sex abuse cases, all of the certification cases, and then any felony dispositions. And then because there is quite a bit of volume below a felony, we have 2 hearing masters who also help us out as needed. They're empowered under Chapter 62 and its various parts to hear pretty much anything a judge could. We made a decision a while ago to have judges hear the more impactful cases, though. And as we were the elected officials and we wanted some accountability, the hearing masters help us fill in all the gaps.
So one of our viewers had a question concerning juries and delinquency. Does that go through a jury process, or is that strictly your show when you're determining delinquency?
They are all bench trials. There's no jury right to a trial currently in Nevada in the family civil division. So, and they do technically fall under the civil division and the juvenile aspects of that division, and there is not a jury trial right.
So that sounds a little different than the criminal arena.
Quite a bit different, for sure. I imagine, and I haven't had this issue happen, but if a juvenile were to be certified as an adult and then they're in adult court and they're charged with felonies, they would have the same rights to a jury trial as an adult in that case.
Okay. Is certification, does that happen automatically if I get kind of spray paint, for example? Do I get certified as an adult on the first offense, or is it quite a process? How's it work?
Well, there are different ways that a youth can go over to adult court. But if it's a young person with a can of spray paint, chances are they're not even going to see the courtroom, because the system is designed to be rehabilitative. These are kids, they're immature, they're risk takers, they're subject to peer pressure, they have an extensive history and story behind them. And so when a youth encounters the system on the delinquency side, they're first going to meet with a probation intake officer who's going to decide what to do with that particular bad act, whether it even goes to a district attorney for a complaint or a petition, as we call it.
So with the juveniles, we've used the term in the larger sense, I suppose. Does the system treat, say, a 6-year-old the same way it does a 14-year-old?
No, and I should hope a 6-year-old doesn't even see the inside of that system. The last time I checked, Nevada doesn't deal with children under 8. Now, I personally believe that should be a little bit higher, just because of the nature of the backgrounds that we're seeing these kids come from, but a 6-year-old's not even going to see that system.
But a different system might deal with their parents, I suppose, if we had a situation like
Correct.
the children that brought the 6-year-old that brought the gun to school recently that was in the news?
Yeah. And shot his teacher.
Right, and that was, that was a different state, and other states do allow kids as young as 6 and 5. Some states don't even have a bottom limit to their juvenile system. In Nevada, we do. It's 8, but in other states, a 6-year-old who brought a gun to school and shot his teacher, or even, I think there was a case in Florida where a 6-year-old threw a very severe temper tantrum and wound up in the backseat of a police car. Here, at that age, if it's a bad act, we're looking at the parents and how do we support the parents with that kind of behavior and that kind of trouble.
Is age something the court would take into consideration when you're looking at these cases?
Absolutely. We take every child where they're at, and I would say very frequently kids that are about 12 and under, they are not even going to meet the requisite level of competency to be treated in the ordinary delinquent course. There is special jurisdiction under NRS 62D 180, which allows the court to take jurisdiction without adjudicating a child in order to oversee services and things that are put in place, rehabilitation, and recognizes that those youth are essentially de facto not competent. And then in the next range, where you're going from 11 or 12 to 14 or 15, if there is a question of whether they're understanding the process, we do competency evaluations there as well, but they would be kind of our typical kids that are getting into contact with the system for the first time. It's rare that we have the younger kids. And then you've got your 16 and up, and some of those youth, depending on what they are charged with, they may be directly filed into the adult system, or they may face the certification process. We can certify from about 15 up. So there are ranges, and the different children are treated differently based on the age range that they fall into as to what the court can do and what resources we might try to draw on in order to divert them from the juvenile system.
You use the word adjudication. Now, adjudication here isn't the same as what we see in the criminal system, right? It's
correct. For a juvenile who's adjudicated, it's not a criminal act, it's going to be a delinquent act. So while they may have been adjudicated of a delinquent act, it doesn't have the same consequences as having a criminal conviction would for an adult.
Okay. Does that follow with them? I know we had some viewer questions about that too. If you are adjudicated a delinquent because you drink and drive, not that juveniles should be drinking, but I bet that you've both seen some of those. How does that work? Does it follow? I know if I got arrested twice, it gets worse, and 3 times I go to prison, right? If under current Nevada law, is it the same trailing process if I've got a juvenile adjudication, or does it not count as a criminal conviction at all? Does that make sense?
It does, and I think we would have to build on your hypothetical to answer that question more fully.
Sure.
So an adjudication is not a conviction, right? Conviction carries with it certain limitations in the adult system going forward, right? From employment being the predominant one, access to services, there's a whole slew of things. With juveniles, they're adjudicated delinquents. So The idea behind it is that delinquent is a child who has committed an act that would be a crime if they were an adult, but we're going to treat them differently because of all the neuroscience and the psychology behind understanding that juveniles are not fully developed in their prefrontal cortex up in here. They don't do that. They don't get all the way there until their mid-20s, right? That's where science is nowadays. So in a situation where you have a youth who's detained, they're not arrested, they're detained for drinking and driving, the first question is going to be what else occurred during that, because there may be certain other bad acts that would cause that youth to go up into the adult system, and then that DUI would follow them along like it would if it were one of us, but.
So if you're, I hate to say this, but if you're 16 or 17, you're kind of taking your chances if you want to push too close to the edge.
Exactly.
You could get treated as an adult particularly if you keep pushing.
Exactly.
Correct.
Yeah, there are a few automatic, we call them direct files, where they may stop off at juvenile detention just because when they were arrested or detained, they met the age requirement, but they very quickly would identify the nature of the charge. And if it falls into certain categories, particularly attempted murder, a violent felony utilizing a weapon after the youth has already been adjudicated before of felony level type offenses, and some of the sexual offenses and things, some of those can result in practically automatic treatment as an adult. And the direct filed cases just go straight to the adult system. They do not pass go. They don't collect $200. They just go straight there. And the court never has jurisdiction of those kids. And we don't see them. And then the next category, the ones that don't fall into that direct file category, but are still involved in serious acts, they may, depending on how the state decides to proceed with the prosecution, they may be subject to a certification petition.
So you bring up a good point. I mean, it sounds like a lot of this comes down to what may be filed or what the state wants to proceed on. Attempt murder is a great example because a fight on a school ground, somebody picks up a small rock, and you could look at that a lot of different ways, I would imagine.
And it really, the way the statutes lay it out, the district attorney's office has almost complete power in how they proceed. They make the final decision on how an alleged delinquent act is charged. Once they make that decision, that determines where it's going.
Oh, that's interesting. So not only don't we have a jury for these delinquency adjudications, we've got prosecutors in charge of things potentially. Not completely, but
at that point you have the Department of Juvenile Justice Services and their probation officers making an initial determinations and whether they even refer it to the district attorney's office. There is a whole range of diversion that is also built in to the way that we approach these youth, and they have the ability either through intake or outside agencies like our harbors to send the children through a diversionary process rather than actually sending it up to the DAs. They do have some obligations to notify victims to see if the victims are requesting prosecution. And at that point, then it must be reviewed by the district attorney's office if that request is made. But the district attorney's office is still the ultimate arbiter of whether or not any kind of charge for delinquency is filed.
So I've got children at home, 17-year-old, 15-year-old, 10-year-old. They've avoided this sort of thing so far. Fingers crossed, right? Always, you never know what might happen. But as a parent, I would have to think this has got to be a very unsettling system.
Of course.
100%.
It has the same uncertainty as the adult court, but almost even more so.
Because you don't know how to prepare, right? Because the burdens of proof are different. The pre-adjudication litigation can be completely different. You're dealing with a county agency on the juvenile system. So yes, it's scary.
Yeah,
as a parent.
I would think. Yeah, I mean, not having my child in my home, just that, right? Not being able to go down and take them out of. I think we called it It's not the detention center, it's they're detained? No, not
Well, they're
detained.
detained, but it is a detention center, and it very much looks like it's part of the penitentiary. It is not a good place to be for a kid.
Okay. It's what we used to call juvenile hall,
Yes.
that sort of thing.
Very similar to a jail, but they're not going to call it the same thing.
Right.
And they may not be with some of the bigger, worse offenders.
If a juvenile offender was certified, then they would be held in CCDC or a similar jail as opposed to the juvenile hall. But anyone who is being adjudicated in the juvenile system, if they are being detained, it'll be there. The other option would be to be in an out of detention placement, which would usually be with the parents at home.
And I suppose if I'm a parent, I don't know if that's a lot of the best way to calm my conscience, but knowing that there are these automatic certifications and some of these perhaps more dangerous, or at least allegedly more dangerous kids aren't next to my child, not going to completely calm my nerves, but it might make me feel a little better, I would suppose.
Well, there's an entire system that the district attorneys and the Department of Juvenile Justice uses to decide whether or not to keep a child in detention. So let's say your 15-year-old and your 17-year-old get into a fight. You're unable to separate them, and Metro takes one of them over to the detention facility. The intake officers there have a point system, and they will make a decision about whether or not to hold that child. Now, with domestic violence, there might be a 12-hour hold, but after that cooling off period, it may be because of the lack of prior offense, the age, the needs, and so on, the ability of you to keep them separated until things can be addressed. They may just release that child and they don't go back into the facility. And I want to say there's like 8 buildings, different buildings where the youth are held.
That sounds about right.
Yeah, I think it's 8.
And the
or
different security levels of those different buildings, is that what we're talking about to some extent, or?
No, they're pretty uniform across the board. They're just divided into units that are supervised by individual officers. There are some more high security type areas where they might need to confine a youth who has indicated some kind of suicidal ideation or self-harm. If it's a particularly violent, youth, based on their experience with them, they might isolate them a little further. But the biggest difference, I think, there's 1 or 2 girl units and about 6 for boys.
That sounds about right. And I think there's one that they use when after they are adjudicated, if they've been committed to the state and are getting ready for transport, so they move them
Transfer to one of the
around.
facilities, yeah.
Yes.
Transport them.
Oh, yes. So after a youth is adjudicated delinquent, one of the things that can happen to the youth as we try to get that youth rehabilitated or into programming to help them is they can be committed to the State Department of Child and Family Services, DCFS. If so, those facilities are not part of our family court juvenile complex. So there's one here in Clark County, there's one up in Elko, and there's one in Caliente. And so if they are committed to the state and the state evaluates them and decides where to go, where they will get the best rehabilitative training, education, what can meet their needs, the state will pick them up and take them to one of those 3 facilities or a private residential treatment center if there's other issues.
And these aren't, it's not like going on vacation, I would imagine, going to Caliente.
Caliente
exactly.
of the 3 would be the closest to vacation, I think, based upon what I've seen and heard about
That
the
one
other
seems
2.
to be the most like a camp type situation. I've had some clients who, having been in the detention hall, want to go to Caliente. They hear that's the best one. It also, in my experience, has been the most difficult for my clients to qualify for. There's certain disqualifiers that would make them not suitable for different facilities.
We see emotions in the adult system, but I got to imagine when you were dealing with these cases, Judge Gibson, that the emotions run high with parents and other things.
Very high. Some of the parents are resigned to repeated activities on the part of their youth and are kind of used to the process. But many of them coming in for the first time, they have a really hard time with it, particularly if you make a decision. Because if a youth is detained, they're entitled to a hearing within 48 hours. We do them within 24 hours. And the interesting thing about that hearing is, though we will give them counsel immediately, they don't have any right to bail. The judge is making a determination as to whether the youth is a flight risk, a harm to themselves or the community, and subjectively making a decision on whether to keep the youth detained or not. And it can seem at least indefinite. We try not to leave it open-ended and to make sure there are plenty of status hearings and to authorize those who are hearing, if the hearing masters are hearing subsequent hearings, to reassess detention status. But there are a number of factors that go into whether you even release a youth or not. And so a lot of the time the parents, they really have no idea of what to expect. They are not technically even really entitled to address the court. They are just required to be there because they are the person legally responsible for the youth. And we don't hold those hearings without a parent present, but the parent very rarely is allowed to interject or really say much. And sometimes it can lead to a lot of frustration being experienced. And really the parent is there to be informed of what's going on with the youth, to be there to release the youth too, if we make that decision to release, and then to make a determination as to whether they want to retain private counsel or not.
But retain private counsel, are they entitled to appointed counsel?
Yeah, we appoint counsel to everybody. Right off the bat, every youth is going to have, at the very least, the public defender's office, juvenile division appointed to them. If there is a conflict, there is a number of contract attorneys who do that for the county as well. Each judge has got a list of attorneys to choose from in the event of conflict, but we give them a free attorney. Some kids do, some families do elect to hire private counsel though, and they would typically substitute in after that initial hearing.
And I have to imagine, as an attorney, a lot of times you're asking for release.
Absolutely. You are asking for release, and in so doing, trying to present that the child will be back for the next hearing, and that they're not going to harm the community, that there are services they need that can't be provided if they are in detention. And it's really about, it's scary for the youth, right? It's traumatizing to be back in there for the first time. Pretty scary. Some of the other facilities are not youth friendly either, even though they're in our youth system. So even in my role on the other side, if I'm aware of a detention hearing of one of my clients, I'm there asking for the release and trying to explain why they're not a flight risk, as well as give the background of the family and the trauma that my client has already sustained.
And sometimes it can be hard to justify a release for a juvenile when there aren't those systems in place as far as, the parents and family support. I've had clients who have had to be placed with another relative because maybe mom or dad aren't a suitable placement because maybe there's another issue with a different child in the home or something like that. And so it can be hard to find a suitable placement for them sometimes. I mean,
I have to think as a parent, it's almost looking inside a fishbowl, for lack of a better description, right? Because I've got an appointed attorney that I have to hope will relay that my home is safe, that my home is clean, that I can provide services, whatever it might be. Now, some of the times that may not be the case, obviously. But I would imagine that's a consideration for release, right? Whether they have a place to go, whether they're on the street.
Yeah, absolutely. If they have a stable residence that they can be released to, we'd consider that. As was pointed out, if there's issues that involve the safety of others in the home, though, that can affect whether or not we can release them. If it's been a serious issue of domestic violence, if there's been a sexual allegation, number of things like that. The other thing that will affect release is the nature of the charge. We are seeing a lot of gun charges. I mean, a lot. And so one of the questions we're asking right off the start is, how did they even get access to the weapon in the first place? And did they get it from the parent's home? Are there unsecured weapons in the parent's home? Are the parents completely oblivious to the idea that their child is running around packing, a weapon? And, and then on top of that, if a gun charge happens at or near a school, there's a requirement that we do an evaluation under Chapter 62C, which is a risk assessment and an upfront assessment as to what kind of services or things might be needed. We will typically, as a matter of course, hold the child for a week so that evaluation process can be completed. if the indication is there's going to be a certification, I'm routinely or had routinely been setting the next hearing out about 3 weeks, because there is a certification evaluation that's done by a psychological professional, which would aid the youth and their counsel in addressing subjective factors under one of the ruling cases with respect to the process of certification. So there's a whole lot of things going on. There may be an immediate need for an alternative placement, and we routinely have parents just flat refuse to come pick their kids up. And Amy, I think, alluded to that at that point. If the youth didn't make points, if the court hasn't determined them to be a danger to themselves or the community, doesn't believe them to be a flight risk, but the parent is refusing to pick them up, it will trigger a call to the hotline at CPS, and the Department of Family Services will also get involved.
Well, and that's what I was going to ask. Are there services, and some of these children, I imagine, just don't have a support network at all. Are there services in place or things that can be done for those children short of remaining detained? Does that make sense? Is there foster care? I don't know.
Yes, that's one option. There are a number of foster homes through private agencies that will take youth who have juvenile justice involvement. If you can get them in the home earlier, the programming can start. So if their defense attorney is looking to get that as the the end goal for the child, that can always be brought up as soon as possible. Number of these youth that are coming in on some of the smaller stuff, not the gun charges that Judge Gibson mentioned, but theft charges, a couple stolen vehicles seem to be popular of late. A lot of these kids already have services, but for some reason it's not reaching them in their needs. And so even though the services might be managed by an outside provider or by a dependency judge, we can actually start talking about, okay, well, he's had therapy, but he's not really going. So what, and the delinquency judge or hearing master can help us get the right providers in, especially if it's a one-time thing, or perhaps it is a particular peer group, and then we can look at taking them out of that peer group as well. But yes, it just like with parents who have abuse neglect cases, the long-term goal is to get them, in a safe place with family, if the family's safe, within their community, if the community is safe, and address the behavior and the underlying cause for the behavior. So sooner they can get in services, the better. In civil law, we talk a lot about, subsequent remedial measures, which you do after something bad occurs. Can't really talk. We don't allow that to affect the law part of the case, but we want the issue to be addressed. So on both sides, we're talking as soon as the parent or the child or the youth want to get engaged, we will talk about that. And that's part of the reason they have the initial intake process with probation under DJJS, is so that if we have a youth who has trouble and is willing to admit it, they can start right then and there. The probation officer will start connecting them with what they need while we're waiting for the court process to go along.
You said DJJS,
that's a county agency, is Department of Juvenile Justice Services.
And it sounds like there's dedicated departments for most of these juvenile proceedings. Is that?
Yes.
Is
They're
that
probably
accurate?
all covered. Yeah, there's different agencies that will address probably any need that a juvenile has while in the juvenile justice system, whether on the delinquency or the dependency side.
Absolutely.
I think there isn't really a shortage of services available. It's just a question of, what are going to be the best services for the child and their family, and whether or not we have people who are interested in participating, both the juvenile and the family.
Judge Gibbons, you're not housed at the Regional Justice Center. You are at family courts?
We are housed at the family court complex. That building and that complex were originally, I believe, purpose-built for exactly these kinds of things, the juvenile involved cases. So Child Haven's right next door. The detention center is right next door. They're all attached and on the greater campus. The juvenile court rooms are all on the same floor in the same wing of the family court building. And those courtrooms, actually the back hall has access to the detention center. That's where they when the kids were appearing in person prior to the pandemic, they were brought down those halls and put into the back rooms there awaiting their court hearing. So it's a family justice center.
Is there an overlap with family court cases on occasion? I would imagine some of the kids that are accused of delinquent acts may have cases in family court with their parents, that sort of thing. Is that common?
I think, well, it's extremely common for overlap with the abuse neglect cases.
Okay.
There are overlap with both the abuse neglect cases and the delinquency cases with the custody and divorce cases as well. It's a little less common, although it does happen. But the overlap between abuse, neglect, and delinquency is very common to the point where there's a dedicated calendar to address those youth and the questions that both courts would be asking. And they call those youth crossover youth or dual status youth.
And does the court have access to what's going on in the family proceedings so the court can tell what's going on with the delinquency proceedings? Does that make sense? Can you check notes back and forth?
Well, in a dependency action, the dependency court has exclusive jurisdiction to basically kind of bring everything to them to deal with the safety issue and then turn it back over to the domestic court. So it's similar with the juvenile justice side. Once the youth enters the delinquency side of things, the juvenile court, the delinquency court has jurisdiction. We have been making some inroads to giving access to our domestic judges and our dependency judges to be able to link cases under one judge and one family so that they can at least access the record of what was going on with a juvenile delinquency or a juvenile dependency case. And as Amy pointed out, there is far more immediately identifiable crossover between dependency and delinquency. However, what I see, I couldn't tell you numbers exactly, but anecdotally, most of the kids that I'm seeing in a delinquency courtroom aren't there because their life is great at home. And so the issues that you would typically see in a domestic jurisdiction are very frequently affecting these kids. And without speaking about specific cases, I have seen a number of cases where the youth was basically acting out as a result of what's going on at home, a divorce proceeding, a custody battle, different things like that. And just depending on how they choose to act out really does affect whether they land in that particular courtroom or not. So I think that it's easy to identify the crossover. And as Amy pointed out, we have a dedicated calendar for each of the judges that's called the dual ward calendar. It's where both a dependency court and a delinquency court have taken jurisdiction over a child. And we try to get both of those large agencies working together and providing their resources or putting pressure on the state to supplement their resources on behalf of those kids. And I think that a lot of work could still be done to identify those emerging issues in a regular domestic case so that we could at least plug these families into some of our front end diversion resources. The big one being the harbor, which now has got about 5 locations and a remote outlying unit. It's a kind of a clearinghouse for services for families, particularly for the lower end offenses and things that the kids find themselves getting involved in. We get a lot of referrals to the harbor straight from the Clark County School District Police. There is a lot of referrals going to the harbor at the intake level when a kid doesn't make the points to be detained. And so they are trying to, with that idea in mind, we're trying to have those kids never even have the delinquency system touch them. So we don't have to worry about a juvenile record needing to be sealed or anything along that line. We're trying to get them services rather than juvenile correction.
And I'm unfamiliar. What is the harbor?
Oh goodness, I defer to Judge Gibson. I'd say that it is essentially a case management collaboration of various agencies to support parents with youth who are showing signs of going down the road of delinquency. So these are the truants, the maybe had a vape pen on campus at school.
Kids acting out.
And so it doesn't have any delinquency, there's no court proceeding to it, but it's designed to help the parents have a conversation with the kid and put them right in services. So the first one was really close to the family court, but now they've expanded to outlying areas. I think this week I heard Mesquite, Moapa, and so it's there to support all of Clark County, and it's been fairly successful.
Yeah, it's a result of an interlocal agreement between DJJS, DFS, school police, Las Vegas Metro, Henderson Police, North Las Vegas Police, the family court. There are a number of community partners that all contribute something to the harbor. The idea being absolutely diverting kids from coming in through our family court doors. And they're up to 5 locations around town now, plus an outlying unit that's going out to Mesquite and Moapa and those areas.
Well, it's very interesting to me because in the adult system, it's kind of us and them. It's the accused and it's Metro. And we are on opposite sides of the fence. This sounds much more collaborative than anything that we do. Is that
much more of a rehabilitative approach, right? So, and I think that's part of the whole point is the juvenile justice system is there to help the juveniles rather than just simply punish them. Because again, these are kids that have a bunch of other issues, whether it's a dependency issue or issues in the home that maybe haven't reached the level of dependency, but a contentious divorce perhaps going on. And so they're kids that need support, and Harbor and all of these other programs are available to offer that support to help prevent any sort of future delinquency or hopefully no adult criminal behavior later on.
So
collaboration is the ideal, and I think nationwide there's a lot of appetite for reform of the juvenile justice system, and depending on what jurisdiction you're in, you may see a whole lot more collaboration than in others. But I saw Amy smile, and I think the reason probably is that she, practically it is still adversarial, and the interests of these various agencies and the court's duty to apply the law and to protect the public does still lead to quite a bit of adversarial proceedings and interests not completely aligning, and that's the balance. You still have to do the fact finding up front. There are a lot of aspects that remind you of the criminal justice system because you're relying on the criminal statutes to define the behavior. The burden of proof is beyond a reasonable doubt, as it would be in a criminal courtroom. But the ultimate outcome is a civil remedy rather than a criminal remedy.
Right, and juvenile justice hasn't been around as long as the adult criminal system, right? This is only something that came around, I want to say in the mid-1800s, and then really we haven't got it in our case law until the last century, the 1900s. And so in terms of collaboration, there's a lot of new work to be done that has been done with the adult penal system, and that's where we're lucky enough to collaborate. However, there are competing interests, and there's no clear answer on it. There are people, victims, who understandably want to feel safe. They want, they want punishment. They can't be made whole, but they want that feeling. And some of that is very important. As a parent, if your child was the victim, you'd be on that other side wanting accountability, punishment, retribution, restitution if it's, if there's money involved. Absolutely, as a mom, that's how I would feel. However, if my kids were one of the accused, I would want them to look at my child, as a child versus an adult. And I think with adults, and all right, so now I'm getting on my liberal soapbox here. I think they should do this with adults too, but with these kids, they're not developing. And like I said, I treat every client that I have that's a child like there's a whole story that begins in utero to the point where I meet them, and involves families and cultures and ethnicity and backgrounds, and I want my child to be dealt with that in mind. And I don't want, all right, you did this is what the sentencing guideline says, there you go. So
not a one size fits all.
Exactly. So I think when it comes to our juvenile system, the social science is very much moving along, and so It allows community partners like Metro, like Family Court, like my office, like the Juvenile Public Defender's Office, and, ACLU, we got all sides to sort of build into it. And kids are a lot easier sell than adults to get people to say, we want to rehabilitate. So there is that, but it still is very much adversarial. We're still in a court system. We still have two tables on opposite sides, right? So it's still...
But as a defense attorney, it is interesting to hear Metro called a community partner, right? I work in a zero-sum game.
Right.
And if I win, they lose.
Right.
And if they win, I've lost. And that's just kind of the way the adult system works. So it's interesting that we've got this integration. Do all Metro officers work here, or do they have dedicated juvenile officers that are trained to understand and maybe be a little more empathetic to some of these needs? Does that make sense?
I don't know the answer to that question, setting aside the CCSD school police.
Right.
Okay.
I think...
And the juvenile probation officers.
Right, and the probation officers, which aren't Metro. Right. They are county
They're a separate agency.
Employees. But Metro or Henderson or North Las Vegas, I don't know that they have specialized officers. Now, certain interest groups have asked them to be trained. So for example, borrowing from your coworker, his son, my son, both have autism. So the autism community has gotten really large, right? And we've gotten in the different courtrooms, and Judge Gibson can talk about, the advance that delinquency court has made. But we started talking to those officers, the advocacy groups, about how you encounter a youth or an individual with that kind of disability. Same with people who have limited hearing, So, but do they have dedicated trained officers? No, it can be whoever is closest responding to that call that's going to encounter that youth.
So you hope you got officer friendly as opposed to Johnny Law.
Correct. Yes.
I imagine you've got some kids that have been traumatized, and you bring up things like autism. We deal with mental illness. Well, you see it with the homeless problem that we've got, and there's not been a good solution to that I've seen. Very desperate situation for people. But we deal with it with people that are charged with criminal offenses too. And you start to see signs of schizophrenia and things in early adulthood. You talked about processes like myelination that don't finish until someone is in their mid-20s maybe. Do you see mental illness in the juvenile system? Are they too young for that to manifest, or is that a common thread, and how does it deal with that?
Oh, so much. There is a lot of mental illness playing a factor in so many of these cases, and you've pointed out, for the kids, it's no different than it is for the adults. We have a dearth of services that are appropriate, for age appropriate, developmentally appropriate for these kids. There is not a lot out there, and it cuts along gender lines as well. If you're female, there's even less. The juvenile justice system, I don't know, I'm sure it came along somewhere along the way that boys are just more delinquent than girls are, is the idea that drove it. But most of our juvenile services are geared towards reforming young men. But we've got weird animals these days. We have sex trafficking going on, and it cuts across any gender line, but primarily the people that we see who have been affected by sex trafficking things are girls, and we've got minimal resources for them. When it comes to the juvenile approach is one of you escalate your correction, you escalate your intervention with the youth as time goes on, and based on the seriousness of what they've been involved with. With the boys, before we get to the point of committing them to the custody of the state, we have a youth camp up on Spring Mountain that is an intermediate stop before they go to what is essentially kid jail, commitment to the state. We have nothing like that for the girls on the other side. It's troubling, because I think as time has gone on as well, with this generation, with traditional gender norms being different, with the change in our environments, you're seeing young girls engaging in the same kind of delinquent behavior that just 10 years ago, if somebody came to you, gave you a fact pattern and said, do you think it was a boy or a girl that did it? you would probably have said back then it was probably some kind of a kid, some kind of a boy. And not anymore. We've got plenty of girls that are engaged in violent felonies, weapons charges, different things like that. And our system has not kept up with those changes either. And then you throw the mental health component into it, and it just gets really sad really quick. A lot of those kids that are on those dual calendars that we deal with are in desperate need of adequate mental health facilities and treatment, and we have very little by way of resources in the state, and then you end up sending them out of state. Our state's funding for those out-of-state placements is much lower than a lot of other states. The problems become myriad and incredibly complex once you inject that mental health issue into it. And I'm seeing more and more and more these cases touching some kind of mental health or disability or trauma factor, all of which need a lot of therapy, a lot of service, a lot of support, and there just isn't enough to go around for these youth.
How does that work with the certification process? Somebody that's 16 to 18, they're in the edge, they're mentally ill, you don't have services for them, and they keep coming back, maybe because of something they can't control or they can't help. Goodness me, it scares me to think that we would send somebody up to the adult system for that reason. And I will tell you about attorneys tell me that was a good idea 20 years ago, and they got basically drummed out of the room. But it's got to be very difficult.
I think based upon, I haven't done any quantitative studies, but based upon what I know that's available here, I think it's sentencing them to a lifetime of problems if they're certified, frankly. So the last time I checked, we don't have a place to house a female who's certified as an adult here in Nevada. I think there's one who's been convicted and they had to send her out of state the last time I looked. With the boys, before they turn 18, they have a facility up at Lovelock. But do they have this? I mean, if we're having a mental health crisis for kids who aren't certified, how are they going to get the services up at Lovelock, right? I mean, the staffing ratio for adults is much, lower than we do for kids. We have kids with, mental health diagnoses, learning disabilities, complex trauma coming into the system, and we're going to send them up there. And all the studies show, the National Association of Social Workers did the study. These kids are going to come out, chances are they're going to commit suicide up there. It's just in the news. If not, they're going to be either sexually or physically abused once they're in the adult system because they haven't had a chance to grow up, but they were certified as an adult because of the nature of their crime and either direct filed or the deferential waiver. When they come out, they come out kind of like with the mentality of a little kid because they didn't get to do things like learn to drive a car, go to prom, all that stuff that a typical kid would do as they're developing. And so they're more likely to need ongoing mental health treatment. They've never had a chance to act as an adult in a public setting, and now we're putting them out on parole and saying, go get a job. And not only do they have a conviction, but they never had a chance to get a job before they committed the crime. And then on top of that, the recidivism rates are just huge for youth who are certified as adults.
Well, I would have to think a 16-year-old would just be subject to all kinds of predatory behavior in the prison.
Yes. And so, if you watched that movie that Oprah produced, When They See Us, about the Exonerated Five, if you ever watch that, then you will see that movie demonstrates some of the abuse. Because those kids, the Central Park Five and the Exonerated Five, the oldest one was 16, two 15-year-olds and two 14-year-olds. And they put them in places like Rikers, Attica. So
that's not kind or gentler treatment by anybody's standard.
No, but see, then you have the parents the family members of the people who are victimized, and they do want accountability, and I'm not in any way minimizing that.
Well, or my child throws a rock and breaks a window, and I don't know that I want them in with somebody who has been accused of murder or sexual assault or whatever it might be. It's very difficult without dedicated facilities in between. I know Nevada's growing, but facilities have been a problem for us for a long time, a lack of diversity of facilities.
Yes.
I think in a perfect world, we would hope that if a juvenile with mental health issues and all of these other kind of soft factors would not be subject to certification then because of those factors, because there is the judicial discretion in the certification process. But unfortunately, we know that it's not a perfect world. So there are plenty of kids that have these issues that aren't going to be addressed in the adult system being sent to the adult system anyway.
So the discretion, that's a very interesting thing with the certification process. And we've used certification and delinquency a little, not differently, but the delinquency is essentially the trouble that you get if you're under 18 and you stay in the juvenile system. And the certification is whether or not you get sent to big boy court. You said the standard of proof's beyond a reasonable doubt for delinquency adjudication. How about for certifications? What's the standard of proof?
Question.
Yeah, it's a completely different approach. Certification's governed by the main case that governs it is in re 7 minors, and there's a decisional matrix that was outlined by the court there. And so you conduct the certification hearing is very much like a preliminary hearing in the criminal system. The first thing that the court has to decide is if there's prosecutive merit for the charges, and that is the burden there is slight or marginal evidence, essentially probable cause. And so the district attorney and the evidentiary standard is it's confusing because it's low in that the state is allowed to utilize police reports, things that would normally be hearsay, and much of it is just argument. But they will lay out, the probable cause there. The court will determine if there's prosecutive merit, and if there is, then we'll go into the decisional matrix. 7 minor says that in order to certify a youth, the court has to have clear and convincing evidence that the youth needs to be certified rather than would be better served by the juvenile system. But it's tricky because the evidence that you're utilizing to make a finding by clear and convincing evidence is very frequently not evidence. And so it's a difficult thing to apply. But I could pause there if you have a question about that part before I went into what the decisional matrix actually entails.
No, I do, because we were talking about this probable cause determination, and it becomes very interesting to me. In the adult system, there are times I've had murder cases dismissed at preliminary hearing, right? And it's usually as a result of cross-examination or other things that have come clean, maybe witnesses go south, whatever it might be. But we also talked about juveniles not necessarily having a right to bail, which is very different than the system I'm used to. So I guess my question is, you said we use hearsay, that sort of things. For these determinations, do they have a right to counsel? Can counsel cross-examine? Can they produce independent witnesses if they want to? Can we do all those things? We can do a full-blown mini trial, for lack of a better description, on a lower standard to try to prevent the delinquency or the certification adjudication?
They can. There's just very infrequently a witness to cross-examine. The in re 3 minors case set the burden very, very low. We don't even have sworn affidavits a lot of the time. It's literally you're going off a police report and then arguing about the nature of the charge. So it makes you scratch your head a little bit, but we also have direct files and automatic certification just based on a charge. So, and age. So that burden is it's low. And so once they meet that threshold of prosecutive merit, then all you're arguing really about is the first step is the nature and the seriousness of the charge. And serious is easy to get. Serious is in the eyes of the beholder, and it's mainly a community standard, and it is subjective based on whatever judge is hearing it, whether it's serious or not. The case does go a little further and gives us this description called heinous and egregious. Doesn't identify it. It's like the old case on pornography. You know it when you see it, if it's heinous and egregious or not. For me, that decision comes from, was it a property crime versus one that actually injured somebody? I have personally made findings that the charges were heinous and egregious when I had somebody who was charged of basically serial rape, or who was charged with a battery with substantial bodily harm and possibly with a weapon enhancement on it, those kinds of things. But you're making, and the reason that you're even engaging in that discussion is the 7 minors cases. It says that you can certify a youth alone if you think the charge is heinous and egregious. You don't even have to go into the rest of the decisional matrix. And the second prong of that is the same. If the youth has been persistently delinquent, and that if that persistent delinquence has been serious in nature, then on that second prong alone, you can certify them. Typically, what you're doing is adding 1 and 2 together. You're not quite getting a heinous and egregious charge, but you're getting a very serious charge. And then what the DA is showing you is the youth's history with the system, and they may have escalating behavior over time, or a spree right in a row that just has been completely unmanageable, or any number of things. And you're weighing those two things together. And the 7 minors court said that if at that point the judge subjectively believes that it should be certified, then it should be certified. Only if there's a lack of persistence in the previous delinquent behavior, or if the nature of the charge doesn't reach that threshold of heinous and egregious, do you even engage the third prong, which is subjective factors. And those are wide ranging. The first one that the court gave us to work with is age. So immediately you go to a kid 16 or 17, they're getting really close to that magical 18 number, and you can use that to tip the scales if you need to certify the kid. The subjective factors is where the certification evaluation comes into play, because often they're arguing that the kid's got a really bad drug problem, or the kid has had a mental health issue, or the kid came from a home that put them in a situation that they are not, their education's been neglected, or their IQ is low, and those kinds of things is where it comes in. And those used to address the mandatory or the presumptive certification statute, which was later basically unconstitutional, but because it put the burden on the kid to rebut these presumptions by introducing evidence of a drug issue or something along that line. But that subjective group of factors only comes into play when it's a close call. Now, in my experience with these hearings, and depending on the state officer that's prosecuting, I have seen the state asking for kids to be certified on their first contact with our system. So in that circumstance, they're really going to play up the seriousness of the charge, because they're going to have nothing on prong 2 to argue. And so they are going to get into subjective factors. And if the kid's older, and if the kid, has been involved or received services of some sort before, or if the kid doesn't have a drug problem or doesn't come from a broken home or anything, they're going to be pushing hard for certification. So one way or another, you're just doing this weird kind of math under this very subjective standard. And then they threw in there for us that community safety, public safety should be the overriding thing that we're considering all the way along the line, rather than the best interest of that child or anything along, and so as a judge who has a duty to uphold the Constitution and to apply the law as it is and is written, and to apply the standard that the case law has given me, I find myself in that circumstance all the time, having to send children to the adult system, and I have nightmares about it. I've seen the movies about the Central Park 5. I've seen the studies about kids and their developmental levels and different things like that. But when I just do the straight math that In Re 7 minors gave me to do, I have a duty to apply it in that way. And that's the most heart-wrenching decision that I make on a regular basis. Second one is whether to commit a kid to the state or not. But the first one is, do I send a child over to CCDC? That keeps you up at night.
I do not envy your position and the decisions that you have to make, but I will say that I'm glad that you have nightmares about it, because it sounds like it can be a traumatic event for the rest of those children's life if something's done wrong or if it's not taken seriously. I mean, essentially, they cease to not only be treated by the court system as children, they cease to be children when they are certified. That is a frightening and a heavy burden, I would imagine.
It's a massive burden. And, you got to be a slightly weird duck to want to be a judge that does delinquency. It's the only way I can say it. It takes, you have to be able to separate what your personal feelings and desires are for the kids of Clark County, from the law that you have to apply sometimes. And, unfortunately, I've certified a lot of kids. I wouldn't say that it's most of the kids that come before me, particularly, every time the state brings a first time contact kid up for certification, you already know that there's no way they meet one of the two prongs, and you're going to have a lot of information presented on the subjective factors that are going to probably help you keep that kid in the juvenile system so that they can receive services and rehabilitative services. But the other thing that we're seeing a lot of right now, and it's probably why some of these are coming in on first timers, is these kids have access to weapons and they are pulling those triggers. And it is really hard to with a straight face, say that, this set of circumstances doesn't present a grave danger to the community, which is the overriding factor under 7 minors. So,
and I think that, children being what they are, my kids come home with all kinds of things. My friend said this, my friend said that. They believe it more than what dad or mom says. But we hear, you're under 18. There's a line from an old
Offspring song.
That's
Yep.
it, yeah.
Yep.
You're under 18, you won't be doing any time,
Yep.
right?
Not true.
Not true. Not true. And those that's one of the great things about the show, I think, is we can hopefully dispel, for maybe a limited group of attorneys that watch it, that myth that you're under 18, you won't be doing any time isn't really the case. And it doesn't sound like juvenile time's that fun anyway.
The kids believe it. And what you'll see is one particular context that I see repeatedly is if these kids are having contact with the gang of some sort, it's the adults in the gang that are putting the young soldiers out in the field. And so they are gambling with this idea that maybe that kid won't actually go to the adult system, and it's part of the angle that they use to convince them to engage in some of the behaviors that they're engaging in. I mean, that's just one circumstance, but it is one that I see, and that I see with some frequency. And somebody, an adult, put the gun in the kid's hand and sent them to do what they did.
What happens if this goes wrong? And let me give you an example, because we've said we rely on police reports sometimes for these certifications. Nevada has a long history of allowing, and in fact requiring, witnesses for preliminary hearing so you can test the state's case. I testified in front of the legislature 20 years ago about this. And I said that the problem is a police report is a lot like a movie trailer or maybe even a movie poster, and wonderful show coming until you get into the theater and see what we've actually got, right? And it is very concerning to me that these things happen on simply a police report. What happens when something's wrong, when the case is certified, they get to preliminary hearing, because they do get those new due process rights again, right? They get the right to preliminary hearing, and lo and behold, there's not probable cause for what they've been accused of. We find out somebody was mad at their brother and lied about them pulling a gun or that sort of thing. Does that stay on the record? Does it come back down? How does that work?
Once it's certified, the juvenile court's divested of jurisdiction. So if it goes up to the adult court, and if they are acquitted there, it isn't coming back down. If it's dismissed there for lack of probable cause or anything along that line, it's not coming back down. It's done. But what you will find, though, is from time to time, it will go up with lesser charges that happened in the same context. And those lesser charges may, in fact, come back down. And so, you know, I don't typically see a case ever again that I've certified, unless there's new charges. Then I may see it again, but I don't typically see it. Once it goes, it goes. But I mean, I'm a gatekeeper on my end too. When it comes into me and I read the detention packet, or I read the information that's given as part of the what's supposed to be the probable cause for a certification, I've thrown them out, and I've denied plenty of them. So, you know, I mean, you want a good judge taking a look at it too, you know, that understands what actually is evidence and what isn't, and understands, you know, and can to some degree determine how reliable some types of evidence are, because I've dismissed charges at that level before. So
I think earlier you may have used the term magic date or magic age, 18. Explain a little more about that. Are they kicked out of the juvenile system at 18? Let's assume there's not a certification.
No. And I've had many clients who said, all right, I'm 18 on Friday, I am out of here. And then the day after, they're still
Got 3 more years, buddy.
Sorry. No, 18 is, you know, it's the age by which, under the law, you know, kids are no longer minors. They can sign contracts and all of that. But the juvenile court, if the act was committed before they reached 18, there's ongoing jurisdiction, and, you know, to see the case through. So there's, I mean,
through Social Security?
I think so. Well, no. Social Security in a different way, but that is a whole nother show about how all of this is funded.
I guess my point is that at some point does the juvenile court divest jurisdiction? Do they have to be done?
21.
We can keep a kid on probation until they're 21 years old. And what you run into, and I think what Amy's talking about here, is the kid's getting close to 20, 21, right around there, and something that they are alleged to have done when they were 15, 16 years old. We see it a lot in the sexual allegation context, comes back and bites them at that point, and they start out in the juvenile system. And we've had 20-year-olds housed in detention with our 14-year-olds, you know, and that 20-year-old is accused of a sexual crime. You know, that's the part of it that just, you know, boggles your mind. And it cuts 2 ways too. You'll have a kid who may have been alleged to have done something when they were 14 or 15, when they're alleged to have committed a crime, let's say in the sexual crime context, or sexual delinquency context. But nobody knows about it or finds out about it till they're 20 or 20 and 10 months. And the juvenile system is going to lose its jurisdiction. There are safeguards to it. They can be charged as an adult, depending on the timing and things, if they are out of our system. But our system needs the general rule of thumb for a sexual charge, 3 years to adequately rehabilitate or treat them. And we lose jurisdiction at 21. It's been an automatic certification in the past. The state has recognized that there's some inequities there from time to time. Some of the treatment that's available, if the youth dedicates himself to it, can be done in a year. And so there's been some renegotiation of some of those cases and things where the state has recognized this isn't a fair result for this kid. And they have entered into a negotiation that gets them around that mandatory 3-year probation, but still gets them the same services. But that's a more recent development. When I was practicing and representing kids in that system, I had cases where the only thing that kept my client from getting the resources that they would have had was when the activity was discovered or confessed, or, you know, and he was stuck. I've had more than one who found themselves basically automatically certified, stuck in the adult system, and a lifetime reporting and registration requirement that they wouldn't have gotten otherwise. And it's because we lose jurisdiction completely at 21. And, and that's that.
And I wanted to ask Ms. Hellman about that because your office recently had a big win in regards to that, right? Tell us a little bit about that.
We did. So this was a case in which our client had allegedly committed some sexual assaults against a family friend while he was about 14. It happened over a period of time, so the age is a little bit unclear, but 14, 15. So certainly a juvenile. And he was not actually charged until after he turned 21. I think he was just shy of 22 when he was actually charged in the adult system. And so we had litigated the case in the adult system and had ultimately worked out a negotiation that was similar to the juvenile treatment of the case. So it would have been probation, it would have included counseling specific to sex offenses, but as an adult, since he was now an adult. And then there was also a stipulation regarding record seal similar to what is available to the juveniles after they've completed like their sex offender counseling in that system. And at the time of sentencing, the district court did not follow those negotiations. So he, at now 23, I believe, was sentenced to prison. And so we addressed the issue with the direct appeal to the Nevada Supreme Court, arguing this jurisdictional issue. And the Nevada Supreme Court did determine a very clear distinction between the juvenile delinquent acts, which are acts committed by juveniles that would be a crime if they were committed by an adult, but are not because of the age of the child committing them, and adult criminal acts. And so if it is a juvenile delinquent act that has been committed, the juvenile court is the only court with jurisdiction, and their jurisdiction will lapse when the child turns 21. So in this particular case, because he was over the age of 21 and it was determined that those were juvenile delinquent acts, there is no court that has jurisdiction over him anymore.
He was done.
He was done.
He was done, but and the cynic is going to say he gets away without punishment, right? Mm-hmm. But the flip side is I have to imagine going through the process is a punishment in and of itself.
And I mean, he was incarcerated in real prison, again as an adult, but real adult prison as a young man. And while, the case ultimately is done against him, I still think that there are punishments that he experienced, both with the court system, with going to prison, and kind of the uphill battle of challenging it then in the Supreme Court as well.
And his name would have been out, right? Whereas a juvenile,
Correct.
we have the confidentiality surrounding that, but his name, even if, he walks away, his name is still associated with that.
That's true. That's true. I hadn't even thought about that aspect.
Right.
I mean, do these that brings up a good point. Do these juvenile proceedings automatically seal? Can I just flip through the records like I can in the adult system?
Some automatically seal at 18. Others, particularly sexual allegations and things, there may be a requirement to register while you're still a juvenile, and then it would seal at 21, or you may have to also petition the court to have it sealed at 21 because it may result in adult registration as well. So there are some statutes that govern what is sealed and what isn't sealed automatically, and then what can be sealed or can't be sealed. So most juvenile delinquent acts those records do ultimately seal, most, by far and large, most of them, but there are some that aren't automatically sealed that take an extra act to go ahead and get sealed.
Right. So there are a number of kids who, when they turn 18, think, okay, it's all behind me, it's all sealed. And that you have to take a closer look at what the delinquent act was, their age, when they were adjudicated, and whatnot. But there's a lot of them that think it's just magic, and it's not.
So, but it's like a built-in statute of limitations of sorts.
In a sense.
In a sense, yes.
Yeah. But I think about the processing and the fact we want to rehabilitate people. And are there situations where the delinquency wouldn't be adjudicated, say, till the person's 19, 20? You do something the night before your 18th birthday and you get in trouble. And it is sent to the juvenile court. It's not enough for certification, and they fight about it for a year for whatever reason. Now you've got a limited time to rehabilitate, right?
Yep.
Mm-hmm.
Yeah, but we do have kids in those situations. We've got them where they're adjudicated after they're 18 and they do the juvenile probation and ultimately, get the same result down the way. A lot of it though, once you get past 20 and you're closing in on 21, you're running out of things that the juvenile system can do.
Yeah, that's what I was going to ask. If somebody in that situation gets in trouble, not a new criminal offense, can you send them to Caliente or one of those places? And if so, do they stay till they're 21 and then they have to open the door? How's that work?
Yeah, really, that is how it works. If they don't parole before they're 21, they'll parole by operational law.
They age out.
Yep.
No, and that's not good, though. I mean, it is, but it's not good because they've been in your hypothetical, they've been in Caliente, which is nothing like Las Vegas. And, all right, good luck. Get yourself a job and a driver's license. See ya.
No, I mean,
so they're going to go right back to what they were doing.
You really hope these kids parole before 21, so at least the state has an obligation to offer some transitional services, independent living, and other things that they have available to them. But it is possible, as you said, that a kid could hit 21 and there they go.
That's the Green Mile scenario, right? They get out with no services and no hope, and
right.
Oh boy, these are difficult problems. Well,
and we haven't really even scratched the surface. I mean, really, you can't in an hour. You can't unpack it in an hour and a half even. But yeah, you're right. There's a lot. It's a complex area of law.
I find it fascinating, and every question leads to another question.
Mm-hmm.
But we do have limited amount of time for the format, unless they have us back, which maybe they will at some point. With that, though, I want to give everybody an opportunity to add anything else that you'd like, anything that we missed, any big thing. I know we've missed a lot.
I think I would be remiss if we kept this discussion as sterile as we have and not look at how certification and that process has impacted poorer communities and communities of color. So I just did a simple Google search of Las Vegas news, juveniles certified as adults, and every kid is not the same ethnicity as me that I saw on the news. And so we don't have data, to my knowledge. I think the most recent state data I could find was from 2017. So we have nothing what's going on right now. Things have changed. I think even the law has changed a little bit. But we have, and that's a whole nother discussion for a whole nother time, because we have disproportionate numbers of kids in the juvenile system. So you've already got this, skew of numbers to go to certification. But if you watch TV, you're going to see that it's not people who look like us being certified. And so the question is, we don't want the victims to be hurt at all. We have to go back upstream to see how to fix it, in addition to looking at the things we've talked about today. And I think that would be a great thing later, maybe on a different platform, to talk about.
I think you're right, Amy. And, it's multi-layered, because it's where do you find that disparate impact happening, or is it systemic all the way along the way? Because I can tell you that when a kid comes in front of me for certification, I'm applying the law, but I don't have any control of which kids have been put forward on a certification petition. And before it even gets to that point, I don't have any control of which kids have been diverted from the system versus charged in the system. And so we're very cognizant of that at the judicial level. I recognize the specter of implicit bias, of all these kinds of things that are built into the system. I am frequently trying to assess my own biases and what I can do, and to make sure that my decision making is not being impacted disproportionately by those things. Some of it is just ingrained in the human brain, but you do your best to manage those. as a decision maker. But there are so many entrance points along the way in the juvenile justice system, and potential diversion points too, that it's absolutely worthwhile studying that and trying to figure out, is this system in and of itself having a disparate impact at some point along the way on these communities? Because there's so many things that affect it. I mean, just right at the detention level, can a family afford a private attorney or not? That basic question will be impacted by their demographics and their history. And so, yeah, is it something that you can even fix? Can you completely root it out? Is, I think, a question that really needs to be asked over and over and over again.
I hope my colleagues at the Public Defender's Office do a decent job down there.
I have a great relationship with them, yes.
But no, I understand the point. Look, and the right person shows up at the right time, and you figure out the kid's got a support system, right?
Right.
I mean, simply, there are certain attorneys that show up, and he's got a support system someplace.
Yeah, I will say, I grew up in a public defender's home, and there are some damn fine attorneys in the public defender's office. And even our conflict counsel, they are to some degree specialists. They have been exposed to this area of law repeatedly, and I've seen differences in the effectiveness of counsel between the appointed bar and the hired bar, and you get that. So I would never be one to just paint particularly appointed counsel with a broad brush, because I've seen some really excellent publicly appointed counsel. And I'll toot my own horn. I had a conflict. I had a conflict track at some point too, and I was a dang good attorney when I was practicing. But I see people like Amy who are just 100% in it for the kids. I've known her since law school, and if my kid was in trouble, I would send them to Amy. But yeah, you're right. There's there's a myriad of things that can be unpacked along these lines.
Yeah, and poverty. Just like there's a correlation with race, I would imagine there's a correlation with poverty that is stark. I remember when I was a kid, the threat was, I'm going to call your mom, right?
You're right.
But because they knew I'd be in more trouble with my mom than I would with the local judge, who wouldn't really care that I'd knocked over a mailbox or whatever it might have been. Not to give too much away, but what if you don't have that support group? Right. Or if they have to work 45 hours a week to make basic rent, pay food at this point, it is very tough. Mom can't drop everything, leave their job to come down and intervene at the local with the next door neighbor or whoever it might be.
Access to care. Taking your example a little bit further, mom's working a part-time job, she probably doesn't have health insurance. That child's on Medicaid. Is that child being evaluated and getting all the services they need? Or have we had this, organic issue just sort of festering? I mean, and that comes, some of that is more prevalent in Black and persons of color's community. So that's to build on what Judge Gibson said, there's many different points where you're going to see these inequities. The result is, though, that the kids that are now being certified as adult, unless it's something extreme for the most part, are the African American and the Latin kids, young people.
Disproportionately affected by everything leading up to it.
And we need to go fix that. And we need to empower that community to fix it.
100%. Anything else to add? Judge Gibson, since you're a distinguished panelist, we'll give you the last word here.
I've talked so much already. I think this was a very good discussion to have. It's a meaningful discussion that needs to keep being had, and I'm happy to be involved in them. And so I just appreciate the opportunity to talk about things that I'm passionate about and that have made up a very significant portion of my career. So, I'm always happy to come back if we want to talk about it some more.
Well, it has been a pleasure, everyone.
Thank you.
Thank you.
For our Nevada judges, I am Scott Coffey. Until next time, have a good day.